Bruce Rivers, he's the criminal lawyer. But who is he? Bruce Rivers, he's the criminal lawyer. And who is he? Bruce Rivers, he's the criminal lawyer. And what he do? And he's gonna react to all the self-snitching.
Hi, this is Bruce Rivers. Welcome to another episode of Criminal Lawyer Reacts, CLR. I'm Bruce Rivers. I am a board-certified criminal defense lawyer, and today is a kind of a cool episode. And it's cool for me because I try cases all the time. I'm board-certified. That means I'm an expert in the area of criminal law. I've been practicing for 23 years. I pretty much only do criminal defense. And today we're going to be doing a hybrid, side-by-side comparison of the Rittenhouse and the Arbery trial. Notice we're talking about the Arbery trial. We're not talking about what the defendants' names are. I don't even remember what they are offhand, but we'll figure that out later. But here's the thing. A lot is going on between those two trials, and they're both going on at the same time. That's what makes this really interesting. But before we do that, I want to give a shout-out to Andy. He's one of our fans, and on Instagram he messaged me today, and I'm telling you, I'm just fucking tickled pink. I just can't tell you how fucking awesome this is. He's a young kid who just got admitted to law school in Maine, and he got a full frickin' ride. Said that in his message to me, he sent me a copy of his letter that you can see here, admission to law school, and he said he'd get discouraged when he was taking the practice LSAT exams. And then he'd watch my videos, and that was inspirational to him. So congrats to Andy. I am so damn proud of you. And that should be a lesson to everybody, that hard work pays off, that you keep your head down, keep your eye on the prize, and do what you got to do to make sure that you get where you want to go. Congrats to Andy for getting a full ride in Maine to law school. Fantastic. Can't even, I almost feel proud like he's my own kid. Anyway, that being said, let's get into this. So this week we had two cases going on at the same time: the Ahmaud Arbery murder trial and the Kyle Rittenhouse trial. And you couldn't have two more juxtaposed cases. And let's just talk about Rittenhouse for a second. And let's just talk about the dynamics that we're talking about here. We're talking about a young kid who is probably right-wing, I would guess. Anybody that, and he testified that he has that AR-15, that particular style, because he thought it was cool. And he was certainly not protesting. He was against the protesters. We have a situation where I think that the moral component of what we're dealing with here is different than the legal component. First of all, if that's my kid, what the fuck are you doing down there with the goddamn AR-15? You stay your ass home. When we had those protests going on in Minneapolis, I had to tell my son Michael, just keep your ass home, and he didn't listen to me at all. He was out there. I didn't have an AR-15, thank you, but he had a camera and documented a bunch of stuff, which was great, But I mean, as a parent, you get really worried about your kids, and you don't want them hurt, and you don't want them out with conflict and stuff like that. And so that's kind of where I'm at with that. And do you want your kid running around the streets that are rioting with an AR-15? Because this kind of shit can happen. That's the moral component. That's the moral component that says, as a parent, stay home. But the legal component, now there's a big difference between the Ahmaud Arbery trial and the Rittenhouse trial. What's the difference? Well, in all aspects of the Rittenhouse trial, he is being chased. He is being chased. He is the chased one. And what did I always tell you? Whoever closes the gap loses the argument. And in this case, it was that Rosenbaum dude. It was the guy with the skateboard. And several other people that were chasing him. They were attacking Mr. Rittenhouse. And that's where I think this case is going to shake out. Now, it just comes down to whether what he did was reasonable. And now here's the thing about self-defense. Before we're going to get into some of the video here in a second, because I think there were some really remarkable moments, and it relates to concepts in criminal law that I think are absolutely fascinating. Now, the Kyle Rittenhouse case is a case of self-defense. And at the end of every case, the jury gets instructed by the judge as to what the law is, okay? So they have to go what the charges are, the duties of the jurors, the burden of proof, presumption of innocence, definitions like reasonable doubt, what reckless disregard means, all these different components. And one of the components that they're going to be talking about is self-defense. When you get into self-defense instruction, now listen to this. You got to listen closely. Self-defense is presumed. That means it's a given fact. So if the prosecutor doesn't prove that he didn't act in self-defense, then he's not guilty of everything. The fact that the prosecutor has to disprove those elements of self-defense is a huge burden, and he has to just not disprove it by preponderance of the evidence, meaning slightly more true than not true. It's got to be beyond a reasonable doubt, and reasonable doubt is a doubt at which one would use in the most important of affairs. That's the typical definition. In other words, it's not proof beyond all doubt, but one that one would the care that one would exercise in their most important of affairs, and there's no mathematical precision to it. It's whatever the jury ascribes to it at that moment. So let's and there was some real fireworks in this trial. So let's go through some of the moments. You have a situation where the defendant in the Rittenhouse, Mr. Rittenhouse, actually testified, and people gave him all kinds of shit. I saw TikTok where there was a little couple of babies and he's crying. I thought that was genuine. I absolutely thought that was genuine. He couldn't catch his breath. He was like a little kid in that moment. You ever see a little kid that just starts crying and can't catch their breath? It is heavy duty. And was he coached? For sure he was coached. Absolutely he was coached. He goddamn well better be coached. But it doesn't change all his coaching doesn't change the underlying facts. It doesn't change the fact that he was being chased and that he shot when somebody was chasing him or grabbing his gun. So, but let's kind of go through some of this right now.
Cornered from in front of me with Mr. Zeminski, and there were
Here's the thing. You don't know how fucking stressful that hot seat is until you sit there. Now, I've had to testify a few times in my day. Once personally for a thing that happened at our house when we were a victim of a crime, break-in kind of thing. And then another time where I've had to testify in my capacity as a lawyer when I've, either as an expert or in another capacity. And it's kind of, there's a weight that sits on you when you are in that stand. Now, if you're a criminal defendant where you're looking at life imprisonment, I guarantee you that that this is not fake. And it's stress. The stress got to him.
There were 3 people right there.
And here's the thing. You've got 2 lawyers. You got the defense lawyer and the prosecutor. And I don't even think it's close. The composure that the defense lawyer has had throughout this entire proceeding was remarkable. Remarkable. Doesn't use invective, doesn't use emotion with the judge when arguing his case. And the prosecutor has played fast and loose with the rules. And we'll get into that in a second.
Whatever. That's what I run.
That ain't fake. That is, I know some of you guys are going to get on, oh, it's bullshit. Bullshit. This is a young kid. He's stressed to the max, and he's sort of reliving what was going on. And his life is on the line, and he knows it. So I don't think this is BS.
He knows if you're going to go into something that's been excluded in a pretrial order, you better ask the court, you better get permission.
Okay, let's talk about this next little clip. This is delicious. delicious when you see a prosecutor get his ass chewed by the court. And guess what you do when that happens? You take a lock, you throw away the key, and you just let them go. And so what happened here is the prosecutor in this case started going into stuff that they already talked about. See, when you litigate a case, before you get to trial, there are motions that you file. It's called motions in limine. And those are things that you want to bring to the court's attention so that they're not objected to, or brought up right in front of the jury because it might be too prejudicial. In other words, the horse gets out of the barn, all of a sudden they hear it, they can't unhear some things, right? So you work that stuff out ahead of time.
This is ridiculous.
It wasn't excluded, Your Honor.
You know why it was excluded in the first place? Because it was propensity evidence. I had heard nothing in this trial to change any of my rulings. So why?
Testimony, Your Honor.
Pardon me?
That was before the
Don't
defense testimony.
get brazen with me.
So when a judge is looking at you and say, "Don't get brazen with me," you're better off just shutting your mouth a little bit and backing down. Because guess who's got the power? The guy on the bench does. And he's got the power throughout the rest of the goddamn trial. And if you want to piss him off, you got to be a good advocate. It doesn't mean you're a wimp. But you have to do so in a manner that's consistent with what the rulings have been. And sometimes you get your ass handed to you in a ruling. I would like to bring up the victim's past, sexual behavior with those partners. And the judge says no. And, and guess what? So if you go like this, judge is going to, what are you doing, Mr. Rivers? You don't make a face. You take the ruling and you deal with the case. But you don't go against the rulings.
You know very well that an attorney can't go into these types of areas when the judge has already ruled without asking outside the presence of the jury to do so. So don't get...
And what he's talking about there, we already talked about this. We already talked about this issue. Now you're going into it when I told you couldn't, and it's trickery. I mean, it's really a dirty pool. It's trying, because I think he knows he's losing, to be quite frank with you, and he's doing things he knows he shouldn't do.
To have an incident where he's making comments about some alleged shoplifters versus crimes that involve instantaneous actions, whether...
Now, this was what they're talking about is, and what they litigated was 12 days before this incident. He is, Kyle Rittenhouse, that is, he's across the street from a Walmart. They see a couple people, and I think we can play that clip here.
Start shooting rounds at them.
And he makes the comment, if I had my AR, I'd fire off a few rounds. Well, he didn't have his AR, and it wasn't in the situation that we're talking about. It was, and there's a rule called 404B evidence. It's propensity evidence. In other words, because he did it before, he's going to do it again. He's predisposed just because that evidence is inadmissible in court. And it is admissible to show motive, plan, opportunity, intent, that kind of thing. But it had nothing to do with what was going on the day that these killings happened.
Premeditated murder or whether self-defense, that's for the jury to decide. But I don't see the similarity. I said it couldn't come in, and it isn't coming in.
And here's the other thing. The prosecution runs the danger of a mistrial when they bring up crap that they're not supposed to. And it's prosecutorial misconduct. And if a prosecutorial misconduct gives rise to a mistrial, guess what? He walks, you can't retry him.
No matter what you think, I said you were over the line and close to or over the line on commenting on the defendant's pretrial silence, which is a...
Now, that's what I'm talking about, what I talked about earlier. The judge has indicated that, you cannot talk about somebody's Fifth Amendment right to against self-incrimination. You have the right to shut the fuck up. And sometimes you should. I mean, most of the time you should. And when you do, they can't hold it against you. And what this prosecutor is trying to do is do just that. And it's black letter motherfucking law. Black letter law. And that's why this judge is getting so animated.
Lone rule. I'm astonished that would have been an issue. So I don't want to have another issue as long as this case continues. Is that clear?
The defendant had.
So, I mean, when you're talked to, I mean, he's been talked to several times by this judge like that. And it just, it doesn't help your case. And here's the thing, as you go along, the jury can feel that too. Even though that was not in front of the jury, the jury can pick up on those subtleties. And one of the things, you know, when looking at self-defense is the reasonable actions of, you know, the defendant. What did he do? Now watch this cross-examination.
With your arms up in the air, he never fired, right?
So with your arms up in the air, he never fired, right?
Correct.
It wasn't until you pointed your gun at him, advanced on him, with your gun, now your hands down, pointed at him, that he fired, right?
Correct.
It wasn't until you were approaching him and your gun was pointed at him. What the hell else are you going to do? If that's not a time that you would use a firearm, I don't know what is. So that's going to be awfully difficult to overcome the self-defense theory for the prosecution. So let's talk a little bit about the McMichaels and Mr. Bryan in the Arbery trial. Now, there was a reenactment that actually happened with one of the detectives. The detective in that case got in a vehicle with Mr. Bryan, who's the one who took the video. And he showed him how he was cornering him and going from side to side to side. And so when I first did my reaction on this trial, on Mr. Bryan's case, I said I didn't know what his role was. And I didn't really know what the facts were. But he was clearly acting in concert, clearly trying to get him to where he couldn't move to the right. So he was like in a ditch, and he was kind of trying to keep him, cornered. And working in concert with the people, with the McMichaels. Now, that is such a different prospect than the Rittenhouse trial. You've got, on the one hand, they're going after Mr. Arbery, thinking that Mr. Arbery is some kind of criminal, and Bryan had no idea. He says in his statement he did X, Y, and Z, or that he thought he must have done something, but he wasn't sure. That's not enough to affect a citizen's arrest. And that's what this case is. Their case is about a citizen's arrest. That's the only justification that they can have for killing this young kid, which is zero, because he didn't do anything. The defense lawyer in this case did. He tried to get Al Sharpton, who was in the back of the courtroom, who he didn't even know was there. It just was brought up to his attention later, kicked out of the courtroom. And he tried to get him kicked out of the courtroom because he thought it was sensational. And he was there. He was asked to be there by the parents. Each parent could have one person that they would let in the courtroom because of social distancing and everything. Here's the thing. You've got two completely different cases. People are comparing them because they're going on at the same time. And so on Friday, what happened in the Rittenhouse trial is the judge and the prosecutor and the defense lawyer, they all sat down and they hashed out what the instructions are going to be. And the prosecutor, feeling the heat of this case, is asking for some lesser included offenses. What are lesser included offenses? So like if you have murder to intentional, you could have murder to unintentional as a lesser included. It's a lesser crime, and the elements of the lesser crime have to be in the greater crime. Okay? So what's lacking in murder to unintentional that would be in intentional? The intent element, right? So that's what they were doing on Friday. And on Monday, they will be giving their closing arguments in the Rittenhouse trial. that'll be interesting to see. And then this is how this goes. So the prosecutor will give their closing argument. The defense will give their closing argument. Then the prosecutor has one more shot at rebuttal. In other words, I speak, you speak, then I can speak about what you speak. So the prosecutor will then talk about the defense's arguments. And then that's it. And then it goes to the jury. The jury is then instructed. Then they swear in the deputy, and the deputy is in charge of those folks. In other words, he is in their custody, basically. And he can't let anybody have any contact with them, and he sits and guards them to make sure that no outside influences impact their deliberations. Then they go and deliberate. Now, what happens when they deliberate? There are a couple different things happen. They pick a foreperson. That's the person who is in charge of taking the votes and kind of runs the jury. And then when they hand in and they fill out the verdict form, then they deliberate. They sit around a table. They go through the evidence, and however they do that is their business. Nobody else's business. There's no rules as to how you deliberate. And then once they come to a verdict, let's say they want to watch some material. They want to watch the footage, because I bet you they'll want to do that. They have to bring them back into the courtroom, generally. I'm not sure if they're going to do that in Wisconsin, because they're going to have something to play the video on. And generally, they don't allow that to go back to the deliberation room. So then if they want to watch the video again, which I bet they do, they bring them back into the courtroom. And then everybody is assembled, and they watch it as if it's the first time. Now, in this particular case, I don't really think that the lesser included offenses matter at all, because it's either going to be self-defense or it's not. And if it's self-defense, he walks. And if it's not self-defense, he doesn't walk. And so we'll see how that goes. Lord knows how long it'll take for the jury to deliberate. I will tell you something about this particular part of the country. It is gun country. And I would venture to guess that you're going to have some people on that jury who are very sympathetic to Kyle Rittenhouse. So we'll see what happens here. I'm pretty confident that if you watched any of this coverage, the lawyers there's a big difference between the defense lawyers in the Rittenhouse trial and the defense lawyers in the Arbery trial. So stay tuned, and we'll keep you updated on what happens here. We love the comments. A lot of comments on these cases. A lot of dynamics, a lot of moving parts. If you want my prediction, which I don't necessarily like to prognosticate these things, but it would be my guess that the Rittenhouse case ends in acquittal, and the McMichael and Bryan case. I don't like to call it the Arbery trial, because it's not. He's the one that died, but he's not the one that's on trial. It is the McMichaels and Bryan that's on trial. My guess is that's going to result in a conviction. So that is my prediction. This has been Bruce Rivers, criminal lawyer, here on CLR. If you are watching this, you should subscribe, like if you like it, and follow us on Instagram, follow us on Twitter, sign up for Patreon. If you 3 months on Patreon, you get a free hat, and we'll see you next time here on Criminal Lawyer Reacts.